very much for that. I want to thank you all for coming today on a day when I would imagine that all of us would rather be outside with our toes in the fountain right now. But thank you for coming, and it's also lunchtime. I appreciate that as well. And thanks ever so much to the library staff for putting together these conversations in Standish, particularly Trudy Jacobson, Irina Holden, and Tyler Norton, who I bugged incessantly about the marketing for this. These Standish conversations, I've been to quite a few of them myself, but now I am honored to stand before you and actually give one of those campus conversations, so it is quite an honor to be here. I want to start my remarks today on this topic with some questions. So what if you woke up one morning and opened up your phone and looked at your news feed and issued an executive order to buy a huge chunk of land at taxpayer expense and just tack it onto the country? What if you opened up your news feed and found that an executive order had been issued to close every American bank for 4 days? What if the president decided by executive order to change the immigration laws all by himself? Or say it's wartime and he decides to detain an entire ethnic group behind barbed wire, or suspend the right to habeas corpus for some people, or try civilians in military tribunals outside a war zone, or seize an entire private industry and have the government run it. Well, now these sound like hypotheticals, but they're not. These are not hypotheticals. These things actually all happen, and they all happen through executive order. Is there anything that can be done when a president takes action like this? Well, yes, but it's very difficult and it's very complicated. Now, because we have less than an hour together here today, this talk will necessarily be a very brief overview of what is a really complicated situation. But what we'll be looking at is what the Supreme Court has done in the past when these kind of actions have been challenged. So let's start with some basics. We all know that the Constitution is set up as a government of 3 branches that are meant to check and balance each other. Our topic today involves just 2 of those branches, the Supreme Court and the judiciary. Now, usually when the Supreme Court gets involved in constitutional issues, it's between the justices and the Congress. Only rarely does the Supreme Court get to weigh in on the actions of the executive, the president. Now, the court has been historically very reluctant to take on issues involving the presidency. And when it does, it usually gives the president wide latitude in foreign affairs and in war making. In other areas, the record has been a bit more mixed. But on balance, the president's authority to act unilaterally has been upheld more than it's been reversed. Congress can also weigh in, but it very rarely moves to repudiate an order, and only very recently has Congress been able to actually sue the president. Now, if I were going to summarize the entirety of my talk today, it would be this one word: precedent. And why precedent? Because we're talking about the Supreme Court, an institution that's very much bounded by precedent. And we're talking about how that court interacts with another government institution, also very much bound by precedent, and that's the presidency. Now, why is precedent so important? Because the U.S. Constitution is so ambiguous. It's only 4,000 words in total, and the part that talks about the president's power is only 320 words. At the rate that I talk, I can cover 320 words in 2 minutes. That's the entirety of what the Constitution says about the president's power. So that leaves lots of room for the people who occupy the office of the presidency to move about and to take powers that may not necessarily be there. So it's not so much the words of the Constitution that matters as how those words are interpreted. And that's where the court comes in. We need the court to fill in some of the ambiguity with decisions. And that's how we've come to a long-standing precedent that determines how the justices make such decisions, and we'll see how that precedent has been applied. So our story starts with a tale of 2 articles. And first is, of course, Article 3, the powers of the judiciary. Article 3, very short, even shorter than Article 2. And basically what it says for our purposes here today is that the job of the judiciary is to settle disputes when they arise under the Constitution. Article 2 is the other article we need to talk about, and those, of course, are the powers of the presidency. This is so frustratingly vague that there are more words in Article 2 devoted to how the president is selected than there are to the actual powers of the presidency himself. So, what are the powers under Article 2? Well, first of all, the president's powers come from 2 sources: the The Constitution itself, Article 2, what does it say? It doesn't say a whole lot. First, it says that the president is to be the administrator of the laws. So Congress passes the law, they send it over to the presidency. It's the executive's job to put that law into action, to make it actually work. That's his job. He can also recommend legislation to Congress. The second area of his power in Article 2 comes from his control over foreign affairs. This comes mostly from his authority as the person who conducts and negotiates treaties for the United States. And the third area is as commander-in-chief of the military. Now, I need to riff here for just a second about this, because you hear a lot of people today talking about the president as the commander-in-chief. Here's the really important thing to remember about that. He is the commander-in-chief of the military. He is not the commander-in-chief of everything. If I am in the military, he is my commander-in-chief. If I'm not in the military, he's not my commander-in-chief. He's the chief civilian authority in charge on the top of the military food chain, if you will. So those are his basic rules under Article 2. The second place where a president can get his authority is from an act of Congress. So Congress can pass a law and say, we want the president to do this, and then he would take that action. So that brings up a question. And there are two opposing philosophies here about the power of the presidency. Is the president to be nothing more than what Carol Berkin famously called an errand boy for Congress, somebody who just goes out there and makes sure the laws actually get executed? Or another idea is the president, because he is the sole executive authority in the Constitution, does that really give him all of the executive authority, and does that make him very, very powerful indeed? So in between those two poles, those diametric opposites, is where the court might be asked to step in to make a decision. Now, obviously, we're moving more in the direction of the unitary executive, the powerful executive over the years since the adoption of the Constitution. So the question is, how has that happened? That makes me turn to the methods the presidents have used in order to expand their authority. And there are 5 main tools in the president's toolbox to do this. And the first is executive orders and memorandums. That's actually 2. But the executive orders and the memorandums are what we're going to be talking mostly about today. So give me just a second here to roll this nifty little thing up.
Executive order.
Executive order.
Executive order.
Executive order.
Executive order.
Executive order.
Wait, what's that really mean? It all starts here at the White House, where a president can create a directive that has the full force of the law without the permanence of one. It doesn't have to go through the legislative branch, as long as it's legal and stays within the bounds of the Constitution. But what if Congress wants to say? The House and the Senate can't directly vote against an executive order, but they can pass bills to change one. The only problem? The president can then veto those bills. Congress can override that veto, but only with 2/3 of both chambers. And given the makeup of the current Congress, that's pretty unlikely. The Supreme Court can kill executive orders, but only if they're considered unconstitutional. And if all else fails, the next president can remove the previous president's executive orders. And in that case, all Congress can do is wait.
So executive orders are the way, basically, that the president tells the governmental agencies what he wants them to do. Now, I have executive orders and memorandums here together, and the reason is because they are so closely aligned that even the courts don't bother to try to find a distinction between the two of them. And if something as minutia-bound as the courts can't be bothered to find a distinction between executive orders and memorandum, then we don't have to bother with that either. They are both orders that direct government officials to do something. Now, the only statutory regulation about executive orders, and there's no statutory regulation on memorandum that I know of, is that they be published in the Federal Register. Nothing else. There's nothing else that tells the president how to do this. They just have been doing it. A third way that a president has expanded or taken unilateral action is through proclamations. Now, these are more for the public. So executive orders, memorandum for the government officials, proclamations for the public. And these are usually things like designating Mother's Day every year, or my personal favorite from the Trump administration so far, designating May 2017 as National Older Americans Month. At least we've gotten away from that senior citizen stuff. The fourth way, is national security directives. These are basically the same thing as an executive order, only they're issued not to government agencies, but they're issued to the national security apparatus. Now, because these are national security, they are secret. There are very few of these that we know anything about, and if we do know anything about them, it's very much after the fact, after they've been declassified. So we don't even know what these things are. And the final way is through signing statements. Now, signing statements, this is when a president is signing a law that Congress has passed, but he's taking exception with something that's in the law. So he may say, I really like sections 1, 2, 3, and 4 of this. They're great, but section 5, I don't like this very much. I don't even think it's constitutional. It's his way to have a voice in the legislation that Congress passes. And I'm asking if it's problematic because the president is not supposed to be involved in legislation. And by saying, I don't like this legislation, he's sort of stealing some of the power, the legislative power, away from Congress. So these things have become a little bit problematic. Now, the thing is, there's been no significant legal challenges to a presidential signing statement. They've been becoming more and more common since the Reagan administration in the 1980s. More and more presidents are doing this. Some examples of executive orders, if you're wondering what some of these executive orders have looked like in the past, I think you're going to recognize a whole lot of these. The Louisiana Purchase, executive order issued by Thomas Jefferson to buy that whole chunk of land that I talked about earlier. Not Congress, they didn't do it. The president did it all by himself. The Emancipation Proclamation, an executive order issued by Abraham Lincoln under his powers as Commander-in-Chief of the military and to take effect in a war zone, which he can certainly do. The Japanese-American Internment Order of 1942, again, FDR's powers as Commander-in-Chief, and he was actually exercising power under a congressional statute of 1942 that said he could do this kind of thing. So this is actually very much at the height of presidential powers. Truman's desegregation of the U.S. Armed Forces in 1948. If we waited for Congress, that probably would have taken a lot longer. Truman decided it was way overdue, and so he issued an executive order. Eisenhower's sending of troops to Little Rock in 1957 so that those 9 very brave young people who were trying so hard to integrate Central High School and Little Rock could actually get through the door. That's also an executive order. And affirmative action and equal opportunity in employment. Most of the really significant advances in these areas have come through executive orders, starting with JFK, also LBJ, Nixon, Clinton, and Obama have expanded that into gender identity and also into gender as well, anti-gender discrimination. So a lot that we can recognize there. Now I'm going to argue that unilateral actions have been on the rise in the last 40 years. And I'm talking about actions of the president now, acting without Congress. Why is that? I think there are a couple of really good reasons. The first one I'm going to suggest is this era of divided governance we seem to be in. Up until recently, Congress and the presidency have been often in different political parties. The period of very hyper-partisanship that we have is going to make any kind of unilateral action on the part of the president more likely. Why? Well, I'm going to give you an example to try to explain why that is. And my example is going to come from the Obama administration and Obama's frustration over trying to get the DREAM Act passed. Now, the DREAM Act, after a tremendous amount of discussion, was passed by the House of Representatives. It got a majority vote in the Senate, and yet still could not be enacted into law because it didn't have the 60 votes that was required by the Republicans in the Senate. And so Obama, in utter frustration, decided to issue executive orders. And the first one is delayed action for childhood arrivals, DACA. I think we all know about that one. And then 2 years later, the deferred action for parents of Americans. So both of those executive orders. Now, what happened after that is a legal challenge. And as Julian Zelizer of Princeton says, when a president releases an executive order, one of the instant responses is to try to tie it up legally. This can be an incredibly effective tool to stop presidents from doing things you don't want them to do. Because as soon as you file a suit, that can effectively stop anything from going into action. So are we in a new pattern here? Well, I'm a historian. I look backwards, I don't look forward, I don't make predictions, but I'm going to go out on as much of a limb as my historian pedigree will allow me to and say this may be a new pattern if we see continuing gridlock in Congress going on. If that is, and the president takes unilateral action that some people may think is unconstitutional, what can we do about it? And that brings us to the topic of checking the president. How does this happen? How often does a challenge to the president's authority reach the Supreme Court? Very, very rarely. And when it does, the issue that is the problem is the issue of standing. In the American judicial system, you can't just say, I don't like it, I want to sue. You have to have a case. You have to prove that you've been harmed. Standing requires real injury. And it's really hard for people to bring a lawsuit claiming real injury. And that's what holds up many of these challenges to presidential action. Now, the challenges that have come, how successful have they been? Well, you win some, you lose some. Professor Jeff Yates here, from Binghamton University has written a book about this, and he's studied these, and he has found that when a president is popular, his executive actions are more likely to be upheld by the Supreme Court or the lower courts. And when the president is not so popular, he's more often likely to see his authority struck down. So it's interesting to look at that. Now, in another study done by the Yale Law Journal between the beginning up until 2013, they looked at 152 cases in the DC Court of Appeals and in the Supreme Court. And they found that of those, 46% expanded or affirmed the presidential authority, only 13% restricted presidential authority. So even when these cases come before the Supreme Court, historically, the court has been reluctant to slap the president down. What types of challenges have there been? Well, the use of executive orders, which is what we're going to be talking about for the rest of today. Also, recess appointments, removal of appointees have been two of the biggies. Now, the Constitution grants the president the authority to appoint people to the federal government and to the federal bureaucracy with the advice and consent of the Senate. It doesn't say anything about removing those people. So if you don't like someone and you want to get rid of him, he's not doing what you think he should do, or he's incompetent, that can lead to challenges. The conduct of foreign affairs has also been the subject of several challenges, and the president's actions during wartime. Now here we're talking about Lincoln, FDR, Truman, and George W. Bush. What kinds of challenges? Well, the suspension of habeas corpus. Lincoln suspended habeas corpus, I think we all realize that, but George W. Bush also suspended the right of habeas corpus to some people. Then there's the issue of the blockade of the southern coast during the Civil War that was upheld by the Supreme Court, by the way. The use of military tribunals, this is Lincoln and George W. Bush both, and the use of detention before you get to a military tribunal, and that's also FDR, and the seizure of private property during wartime. Now, this is the case that set the precedent that is going to determine the future of presidential actions in the future. And that brings us to this man right here. Justice Robert Jackson, a man with very deep New York roots, born in Jamestown, New York, spent a year at Albany Law School, and then became an Associate Justice of the Supreme Court. Now, Jackson is on the Supreme Court in 1952 when Truman is faced with a situation in the Korean War. He was faced with a very real prospect of a steel strike. And he decided he couldn't allow that, so he issued an executive order authorizing the Secretary of Commerce to seize the steel mills and to run them as for the government. When he did this, he painted a very dire picture for the American people.
My fellow Americans, tonight our country faces a grave danger. We are faced by the possibility that at midnight tonight, the steel industry will be shut down. This must not happen. Steel is our key industry. It is vital to the defense effort. It is vital to peace. We do not have a stockpile of the kinds of steel we need for defense. Steel is flowing directly to the plants that make it into defense production. If steel production stops, we will have to stop making the shells and bombs that are going directly to our soldiers at the front in Korea. If steel production stops, we will have to cut down and delay the atomic energy program. If steel production stops, it won't be long before we have to stop making engines for the Air Force planes. These would be the immediate effects if the steel mills closed down. A prolonged shutdown would bring defense production to a halt and throw our domestic economy into chaos. These are not normal times. These are times of crisis. We've been working and fighting to prevent the outbreak of world war. So far, we have succeeded. The most important element in this successful struggle has been our defense program. If that is stopped, the situation can change overnight. All around the world, we face the threat of military action by the forces of aggression.
So Truman is very much interested in seeing this executive order upheld. But you can imagine that the response from the steel industry is very different. So what we're going to have here is a classic confrontation. Truman versus the steel owners, and it's going to play out in the Supreme Court of the United States. Now, the president is going to claim, I'm the commander-in-chief, I have the authority to issue an executive order like this, I have to keep the steel mills running. You heard his dire predictions if they didn't. And then he also claims that under the Selective Service Act, which empowered him to do everything he could in order to keep production going. It didn't say he could seize companies, just said it empowered him to do what he could to continue to encourage this. He's going to say, between these two things, I have all the power I need in order to seize the steel mills. Not to mention the fact that FDR had done it during World War II, he'd seized the coal mines. Now, the steel companies, on the other hand, are going to say, okay, Mr. President, Pittsburgh is not a theater of war, and therefore an executive order like this should not have the force of law. And secondly, Mr. President, when the Congress thought about giving you this exact kind of power when they were discussing the Taft-Hartley Act in 1947, they declined. They decided not to give you that exact power that you are now seeking to exercise. And so we come before the court, and in a case named Youngstown Sheet 2 versus Sawyer, this is not good news for Harry Truman. The court slaps it down, says the executive order is indeed unconstitutional. You can't seize the steel mills. Now, it's an important case for that, but it's far more important for a concurring opinion that was written in that case, and that was our friend who I just showed you, Robert Jackson. Robert Jackson, in this concurrence, created a three-part test that he thought would be very useful for categorizing future presidential actions as either constitutional, unconstitutional, or maybe. So let's look at this three-part test. The first one, he says, when the president acts pursuant to an express or implied authorization of Congress, he's at the height of his powers. He's acting constitutionally. And a little parenthetical note here. You notice I keep using the male pronoun? Well, I'm using the male pronoun because all the presidents have been men, but that's why I keep doing it. He's at the height of his powers. It's constitutional. Why is he at the height of his powers? Because then he's exercising all the power of the federal government. He's exercising his power as the executor and administrator of the laws and the commander-in-chief, and he's also exercising all the powers that Congress can delegate to him. You can't get much better than that, so thumbs up whenever that happens. Now, this is the second category, when Jackson says, in the absence of either a congressional grant or a denial of authority, he says, then we go into a zone of twilight, as he calls it. And he said, this could happen if there's a new situation that arises that Congress hasn't even had a chance to think about yet. The president responds more quickly, or if Congress has failed to act, either because it doesn't want to or because of just inertia. Then, if it comes into that situation, then it might be a gray area. Maybe it's constitutional, maybe it's not constitutional. We'll look at each one of these individually, and we, the Supreme Court, will decide. The third category then is when the president is at his lowest power, when the president takes measures incompatible with the expressed or implied will of Congress. Then he is against the will of Congress, he's at the lowest ebb of his power, and the only way the Supreme Court will find that that is constitutional if the president can assert that he has the only authority to act and no one else has authority to act anyway. So those are the three zones that he's going to use. At his highest, when he acts in concert with Congress; at his lowest, when he acts against the implied will of Congress, or when Congress doesn't do what he wanted to do earlier; And then, yeah, maybe yes, maybe no, in that zone of twilight area. So that gives the president some degree of latitude. It gives him some degree of being able to expand his powers. That zone of twilight cases will help him to do this. Some examples. Number 3, he's at his lowest in that Truman and the steel seizure case that I just talked about, because Congress refused to give him that kind of power under Taft-Hartley. So that's a thumbs down. Number 2, that zone of twilight. Well, we see this in a 2014 case that arose. This was a case for the Obama administration. Now, Obama was very frustrated because the Senate was failing to confirm many of his nominees to boards and to agencies. And so Obama took advantage of a 3-day recess, a 3-day senatorial recess, to use his constitutional authority to make recess appointments, and appointed 3 people to the National Labor Relations Board so they could at least conduct their business. Well, there was a decision that came out of the National Labor Relations Board, and the person who had that decision didn't like it. He sued and said, these 3 people should never have been put on that board. It's an unconstitutional action, and this is not going to stand. And it didn't, because the Supreme Court looked at this and said, Mr. Obama, we understand your frustration, we feel your pain, but 3 days is not long to say that this is a constitutional a senatorial recess. So that's a zone of twilight case that was a thumbs down, not a thumbs up. Now, through 2015, 83% though of the cases that came in the zone of twilight area, 83% of those cases were the president's power was upheld. So this is a case where it was not. This is one of the more unusual ones. And then, number 1, at the height of his presidential authority, this is unpleasant to think about, and this was not actually a case, but if it had come up, it would have been the Japanese-American Internment Order. The president was using his powers as commander-in-chief. He was also acting pursuant to an act of Congress in 1942 that said he could do this kind of thing. If this had come before the Supreme Court, it almost undoubtedly would have been the height of presidential authority, and it would have been upheld. So that brings us to another question. Can Congress sue the president? We know that companies can sue the president. We know that groups can sue the president. Can Congress sue the president? Well, only very recently. In 1979, when a group of senators decided they wanted to sue President Carter because he wasn't living up to the treaty obligations they thought he should have, the Supreme Court said, no, Congress, you can't sue the president. You are a co-equal branch with the Congress. You have lots of tools in your bag. If you want to fight the president, there are lots of ways you can do it. You're not helpless. So you should not avail yourself or not be able to avail yourself of the judiciary in order to bring a suit. Find some other way to do it. So they did not have standing here. But we have a big shift recently. The 2013 case that found the Defense of Marriage Act unconstitutional also carried this test as well as to whether Congress can bring suit against the president. And this is what U.S. v. Windsor said. If one house agrees to bring suit, and it doesn't have to be the entire house, it can be their lawyers decide to bring suit, and if no one else can bring that suit, and if a presidential action nullifies the act of Congress, then Congress has standing and it can sue the president. We can talk about this more. I have a couple of examples of how this is working right now. So we have a very recent shift that will make it easier for Congress to sue the president than they could have before. There are 2 cases now pending on this very topic. One of these is a 2014 House suit over Obamacare payments to insurers. This is the John Boehner lawsuit, which some of us may remember. He famously said he was going to sue the president over that because it was an executive order that was spending money and giving money to insurers, and it was money that had not been authorized by Congress. Under the Constitution, it's Congress that gets to authorize money payments, not the president. And so that case has come before the Supreme Court. It's still hanging out there. It hasn't been resolved. It's still hanging. In 2017, just last month, 196 Democrats have decided to sue the Trump administration over the Emoluments Clause. Now, up until the Trump administration, nobody ever heard of the Emoluments Clause. Now, all of a sudden, it's a big deal. And it basically says that presidents or high government officials can't accept gifts from foreign countries. What the framers were worried about, they're worried about bribes. So some people look at the Trump administration, or President Trump himself, and his refusal to divorce himself from his businesses, particularly his Trump hotels in Washington, D.C., which are receiving money from foreign governments when their delegations come and stay in the Trump hotel. And these Democrats are claiming that is an emolument, and it's a violation of the Emoluments Clause. Up to this point, there have been no cases around the Emoluments Clause. Where this is going to go, I can't begin to tell you. It's just been filed, and nothing else has happened with that. Now, cases since this Youngstown case that has actually that set this precedent that I'm talking about, the major cases that are involved here are the ones surrounding the Guantanamo Bay detainees. During the War on Terror, President Bush used the authorization to use military force. This was Congress's authorization that said that Bush could send troops in on this war in terror when he wanted to, or when he thought it was necessary, I should say, and his commander-in-chief powers to decide who was an enemy combatant and who could be held offshore, but in an area controlled by the United States. And that area, of course, is Guantanamo Bay, Cuba. And the Bush administration also using the authorization to use military force from Congress and the commander-in-chief powers set up military tribunals in which those those enemy combatants would be tried. So there are 4 major cases that come out of this situation, and they all have to do with habeas corpus, that bedrock right that we all depend on, the right that we can't be thrown into jail and held indefinitely without a government official bringing us to court and charging us with an actual violation of some sort. Now, these enemy combatants were being held in Guantanamo Bay. They did not have the right to habeas corpus petitions, and they did not have a right to have their charges, any charges leveled against them and heard in a court of law. So the first one is in 2004, Hamdi versus Rumsfeld. Hamdi was an American citizen, and he was being held as an enemy combatant in Guantanamo. They transferred him to New Jersey when they found out he was an American citizen, and said that he had to have the right to some kind of hearing. The same day the Rasul v. Bush case came down, that said the same thing for non-Americans. Even if you're a non-American, you can't be held on Guantanamo Bay soil and claim that that person doesn't have rights to habeas corpus. Now, in 2006, the court said that those military tribunals that the Bush administration had set up for these enemy combatants in Guantanamo, they said that they both violated both U.S. law, they violated the Uniform Code of Military Justice, and they also violated international law as well, and struck down those military tribunals. Congress, wanting to help the president, responded in 2006 with the Military Commissions Act to try to make those military tribunals pass constitutional muster. That didn't work very well because 2 years later in Boumediene v. Bush, those military tribunals, as set up by Congress, were also slapped down, and the court said, you know, you can't decide, you can't turn habeas corpus on and off. If someone is charged with violating an American law, wherever that is, and even if it is offshore in Guantanamo Bay, that person still has the right to petition for habeas corpus and have his case heard by a judge. Taken together, these 4 are a major curtailment of the expansion of executive war power. Up to this point, the courts were very, very solicitous of the president and his ability to make war. This is a real turning point. This is a shift here. But it's also a slap at Congress, because they're also slapping down Congress here. Remember I said thumbs up when the president is acting under his power as under Article 2 power, but then also acting under an authorization from Congress? That's exactly what the president was doing here in Boumediene v. Bush, and the court still slapped it down because they said, well, we're sorry, President, maybe you thought you were acting fine, but the law itself was unconstitutional. And so both Congress and the executive go down in that situation as well. Now, Jackson's test has been slightly modified. It's still good law, and when I say it's good law, that means that it's still something that is used in court. It was slightly modified in 2008 by the Roberts Court, when Justice Roberts handed down a decision called Medellin v. Texas. And in this case now, what they've done is they've taken that zone of twilight, which I think Jackson meant in order to enable the president to be able to react to new situations if necessary. And now the Roberts Court is saying no, that the only way a zone of twilight case is going to get through is if it is a situation where the president has been doing something for a long time, Congress has known he's been doing it for a long time, and they haven't said anything. They acquiesce in whatever it is. In that case, it will be upheld. If it's anything other than that, the court will probably strike it down. So this is looks like we're moving into a period of slightly more restriction on the power of the president when he claims to move beyond his authority under a congressional enactment. So I have a question mark here. Does this effectively end Jackson's gray area, his zone of twilight? We haven't seen too many cases involving this yet, but there have been 51 times that this case has been cited and it has not been overturned, superseded, or distinguished. So the court is pretty happy with this decision. Justice Jackson's three-part test still stands. It still stands today. It would be used, but it's been slightly modified by Medellin. The most recent Supreme Court decision, there is one that up until a few days ago I had to change this because it changed in the last 2 weeks or so. And this is Obama and the deferred action for parents of Americans. This is a case coming out of Texas when Obama issued the executive order saying that parents of dreamers, so the illegal immigrants themselves who brought the dreamers in, should also have a 2 or 3 year window to be able to work and then petition to stay in the country. This was 15 states attorneys, I'm sorry, that was 25 states attorneys general brought suit against this, saying this would cost them a great deal of money to actually institute this law. So that was their claim of standing. The court said, yes, okay, you have standing, and it was struck down in the district court. But the district court judge said, I'm going to strike this down, but I'm going to put a stay on this order. And then it came before the Supreme Court. This was when Merrick Garland's nomination to the Supreme Court was being held up, and the court was at 8 members. There was not an uneven number, and the court split right down on ideological lines, 4-4. And when that happens, when there's a tie vote in the Supreme Court, the highest lower court decision stands. So this deferred action for parents of Americans is dead, and the court gave no reason for this. They just refused to overturn what the Court of Appeals had done. So that's done and it's over with. Now that brings me to the current court and what might come before the current court. There are some cases. This is the case that I was talking about that is probably going to be moot. This is a case brought against Donald Trump's second travel ban, and the argument is against this that it violates the Establishment Clause because it really is a ban on Muslim immigrants into the United States. This has been superseded by a new proclamation from President Trump on September 24th. They backed off from that ban, the second ban, and now there's a third one. This is the one that goes into effect on October 18th. This one, because it's a new ban and the other ban is gone, that will effectively make this moot. The Supreme Court will probably not ever hear arguments in this case. And as I said, I look backward, I don't predict, but I think this new travel ban is probably good enough that it may pass constitutional muster. The earlier ban, probably not. This one probably will ban. But so there's nothing actually pending before the Supreme Court right now. There are some cases in the lower courts, though. The case I talked about earlier about the Emoluments Clause, that one that the congressional Democrats are bringing. There's also a suit against, Trump's executive order banning transgender people from the military. There's a suit that is questioning the executive order that removes or threatens to remove federal funding from sanctuary cities. And now there's one that's still holding out there on the deferred action for childhood arrivals. That one is still out there and still could, be heard. And then this is the most unusual situation I've ever heard. There's also a suit against the termination by the Trump administration of DACA. So we've got two suits, one on either side, one questioning DACA and one questioning DACA termination. So I don't know how this one's going to play out. I have no idea. And finally, that last one, House versus Price, that's the Obamacare one. That one is in abeyance right now at the Court of Appeals. I don't think this one is going anywhere either because the Trump administration doesn't want the payments that the Obama administration was suggesting be there, but they can't afford to say we're going to stop them because there's nothing to take their place, because the repeal and replace of Obamacare did not work. So and right now they're in a 90-day holding period on that case. Who knows where that's going to go? I have absolutely no idea. And last thing, we may have a new issue. The issue of presidential speech. What a president says about what winds up being executive order has not really been an issue. There's no doctrinal regulation on this about whether we should pay attention to what a president says in speeches or in memos or anything like that. But we have a president now who's doing a whole lot of speaking. He did a whole lot of speaking during the campaign about wanting to ban Muslim immigration and his tweeting as well. So we may see coming up here that these presidential tweets and presidential campaign statements may actually be used in challenges against presidential executive orders. Again, I don't know. Stay tuned. I'll let you know what happens on that. That I'm not sure of. And I'm going to let Justice Jackson have the last word today. This is from that concurrence in 1952. He says, one may be surprised at the poverty of really useful and unambiguous authority applicable to concrete problems of executive power. Indeed, a century and a half of partisan debate and scholarly speculation yields no net result, but only supplies more or less apt quotations from respected sources. That was 65 years ago, and I'm going to suggest that we haven't made a whole lot more movement toward anything to clear up the ambiguity of the constitutionality of executive orders. Thank you very much.